Hello, IBUS 340 students. Okay, now we're getting into the lecture material. So I am in my Peter Holden persona. I am not Benton Counter, and I am not Will Argue. I am instructor Peter Holden. As I indicated in the introductory lecture, we don't go chapter by chapter through the textbook. You're going to have to hunt and peck to read material if you need to. But I have broken it down into topics, and so we're going to get into topic 1. However, first of all, I have to look at screen 2, and if you're following along, you'll note that right there it says the lectures, or the lecture guide is not intended to be notes. Okay, it's merely my idiot's guide so that I remember to do the things that I'm supposed to do and comment on topics that I'm supposed to comment on. You are expected to take notes and fill in blanks. On the lecture guide screen, I have put in definitions whenever I possibly could, but sometimes it's just too long to put in there, so you have to remember to take notes. Okay, the second thing on that screen is warning. Warning. Neither this material nor the lectures or comments made by our instructor in class are intended to be legal advice for specific legal problems. Students with legal problems are advised to consult legal counsel. I have to put that in there because up until December 31st, 2018, I was a practicing lawyer and I did international trade law as well as other things. As a consequence, the material tends to be very practical. The problem is if you just take the materials and apply it to a legal problem that you may have or may encounter later on, the materials might not cover the subject adequately. There's always two sides to the situation, and that's why you have to get legal advice, because then your lawyer listens to your side, does investigating, listens to the other side, and then he or she will be able to give you the best legal advice possible. Okay, next slide. I found a Dilbert cartoon, and I put it in there because cartoons show life. And one of the aspects of Peak Performance Pontoon's strategic planning will be the possibility of outsourcing. And so I found this Dilbert cartoon, and it dealt with outsourcing, so I just had to stick that in there. Okay, introduction to international trade and law. What we're going to do is we're going to look at the law in the Canadian context, and then we're going to get into international law so that we can do a comparison. What is law? 3 components to the law: protection of persons and property, provides government the power to act for the benefit of society, and it provides us with a broader freedom of choice. Just very quickly to flesh that out, protection of persons and property, automatically we think criminal code. Yes, that's one aspect of it. But it also allows you to protect your contractual arrangements and your property concerning that, because you have the right to go to court and sue someone for breach of contract or from trespassing on your property and that sort of thing. Okay, it provides the government with power to act for the benefit of society. You see that in the North American Free Trade Agreement, which has now been supplanted by the USMCA. The government is acting for the benefit of Canada as a whole. There are a lot of people that were opposed to free trade, but the government said, okay, yes, sure, some are opposed, but it's better for society as a whole, and so they implemented free trade. Part and parcel of the government's right to expropriate property or to enter into trade agreements that you may not particularly agree with is the rule of law. And I'm really big on the rule of law. The rule of law is what allows democracy to work. To the south of us, we see the United States, where President Trump and his cronies, particularly his Attorney General, are systematically chipping away at the rule of law. And Trump is, I'm quite convinced, and I'm on my soapbox here a bit, but I'm quite convinced is trying to become the dictator of the United States, just like Putin is the dictator of Russia. The rule of law is the only thing that stands between that happening and saving our democracy. It's under attack down there. It could could be under attack up here. It's something that we cannot take for granted. Okay, the third one provides us a broader freedom of choice. Okay, I'm going to sell you my car and you're going to buy it. So here's the keys to the car, give me the money. Okay, that's fine. But what happens in business when I say, I will give you my goods on 30, 60, 90-day terms? Obviously, if you had to have the immediate give and take in a contractual arrangement, your freedom of choice for the way you want to do business would be curtailed. But the very fact that I can enforce my contractual rights in the event that you do not pay me in 30, 60, 90-day terms gives me a wider, broader freedom of choice. It also relates to things like the manner in which you want to live your life. Or do you feel that you would rather live your life as a woman or a man, or and so it allows you to have same-sex marriages and things like that. What really makes the legal system work in Canada is that you do have a whole system of prohibitions and punishments. Prohibitions like, you can't rob somebody, you can't commit a fraud, you can't assault and batter somebody in the criminal code. Those are prohibitions, but you also cannot breach a contract, which is a civil matter as opposed to a criminal matter. For criminal matters, the punishment is fines and imprisonment, or both. In contractual matters, it would be injunctions and damages. And in tortious matters, it could be injunctions, damages of a general nature, specific damages, and that sort of thing. I have posted to eLearn an article called The Perils of Legality. I like this article because it really talks about the development of international law, and it also it brings us to the next problem, and that is there such a thing as international law? And I mean, you think, well, yeah, there is, but not like the Canadian legal system, where if someone infringes your rights, you have the ability to go to court and sue them for breach of contract, and then if you are successful, you have the ability to then begin enforcing your judgment. Internationally, it becomes a lot more difficult, and because of the cross-border nature, there's no system of prohibitions and punishments. There's no unitary law system. The article says there are law-like regimes, okay? So we have some conventions by the United Nations which provide cross-border activities and prohibitions and punishments. We have the World Trade Organization, which again prohibits certain activities and has a somewhat workable system of punishment or enforcement. But the thing about that article was that the thrust of the article was that it was dealing with the problem faced by George W. Bush, who is the son of the first President, George Bush. President George Bush departed from the way the Americans used to approach international affairs. When Iraq invaded Kuwait, George W. Bush, through their ambassadors, went to the United Nations and said, the Security Council, and said, we have to do something about this. And so a coalition of military forces with the auspices of the United Nations went into Kuwait and pushed the Iraqis back into their own territory. George W. Bush wanted to finish the job that his father didn't do. He wanted to eliminate Saddam Hussein, and so he tried to say let's go in there and get rid of the weapons of mass destruction, which was his way of getting everybody together to do battle. It was pretty clear at that point that there were no weapons of mass destruction. Anyway, he wanted to do that, and he could not get the United Nations to to agree, and so he got a coalition force made up of the U.S., the U.K., and some other smaller countries, and then went in and went after Saddam Hussein. The whole thrust of the article was, the United States will rue the day that they actually went to the United Nations and tried to get their help to go into to defeat Iraq the first time, because the second time, gosh, look what happened. So what the article is really saying is we're big, we're tough, we should be able to do anything we want. But the interesting thing about the article is that it talks about the systems for international law that are there, and then the lack of prohibitions and punishments. I have written an article a few years ago called The Convergence of the Civil Law and Common Law Systems, and I referenced that Perils of Legality article, and I also referenced another one written many years later, because I think the Perils of Legality is like 1997 or something. But this later article, many years later, said exactly the same thing, putting it in different words. They said there's no policeman on every corner. So this lack of ability to enforce the laws internationally is where the problem crops up. Returning to the Canadian system, first of all, very quickly, in BADM 107, I'm not sure all instructors do it as much as I do, but I talk about the 8 sources of law. And there's judge-made law, so judges' decisions in areas like breach of contract, because there's no contract act, okay? Judges' decisions in torts like negligence and battery and false imprisonment, because there's no statutes that regulate those. There may be a section in the criminal code that provides some relief that way, but generally if somebody falsely imprisons me, great, they get charged and convicted and the government gets a fine, but what do I get? So I have to go to court and sue. Well, when I sue, I want to get precedent to help me win my case, I have to go to judge-made law, okay? Statutes are also not considered to be final and binding until they've been judicially interpreted. Okay, so that's number one, judge-made law. And then there's statutes and regulations. Statutes, like what am I talking about? The Sale of Goods Act, the Human Rights Code, the Criminal Code, Competition Act. You know, you could go on and on and on because we're a very overly regulated society. So those are the statutes. The government has decided that certain laws should be written down for clarification. The meaning of those particular statutes, or the meaning of sections in those statutes, really has to be judicially interpreted, and again, that's judge-made law. What are regulations? We have a labor relations code in the province of British Columbia, which talks about how collective agreements must be negotiated through collective bargaining, disputes must go to arbitration, and all sorts of substantive law. But then, okay, so if somebody doesn't bargain in good faith, they're like, what do you do? You got a statute that says they're supposed to, but what do you do? Well, the regulations allows for enforcement of the substantive law. And so we have the labor code regulations as well as the statute. And a minister is designated in the statute as the person that will develop the regulations for enforcement of the statute. Order in council. An order in council is a way that a government can pass routine legislation, even though it's going to be a law. They don't have to go to the Parliament or the legislature and enter a bill and have it in first reading and go to second reading, go to third reading and vote, and then have it proclaimed by either the Governor General or Lieutenant Governor, because it's so routine, like nobody cares, so why spend the time? So what can happen is the Attorney General can draft legislation for a certain subject, For example, and I'll use the provincial one because I've got a copy of it and I'll be able to post it on eLearn for you, so you know what an order in council actually looks like. The Registrar of the Land Title Office wanted to, instead of keeping hard copies of documents, put them on CDs. But the law said that it had to have a hard copy. And so he wanted to change the law. Do you care? No. Do I care? No. Do the lawyers care? No. Do the real estate agents care? No. Nobody cares. I only cared when I was a lawyer and I had to get a copy of a covenant or a copy of a mortgage. I could contact the registrar's office and he could give me a copy. I don't care if he prints it off a CD or if he photocopies a hard copy, as long as I can get it. So we don't want to go to have our legislature debating this bill. So the the Attorney General drafts the legislation, attaches it to the order in council. The presiding member of the Executive Council, which in BC is the Premier, signs it. And then it goes to the Lieutenant Governor, who signs it, and it becomes law. Okay. Federally, the orders in council were used extensively when NAFTA first, when the Free Trade Agreement first came in with the United States and Canada, because we had to reduce over a 10-year period all the tariffs on various items from whatever they were down to zero. Who cares about reducing the tariff 1% on rubber boots this year and 1% on rubber boots next year and 1% on rubber boots the following year? Nobody cares. The government cares. The minister responsible for international trade cares, but nobody else cares. And so they do it by order in council, and it just facilitates things a lot better. Okay, now to flesh it out, obviously Canada is predominantly a common law jurisdiction. We have 9 common law provinces and 3 territories governed by common law as well as native law. And then we have Quebec. Okay, and Quebec has a civil code, unlike the common law, because it was originally a French colony. So we have to consider that the civil code is part of the laws of Canada because there are differences between that and the common law. Administrative law. Administrative law is, I guess the best example is labor relations legislation. Okay, if there's a dispute between management and union, it goes to the Labor Relations Board, who makes a decision. And that decision looks like, walks like, and talks like judge-made law. But it's not judge-made law, and it's not judge-made law because the tribunal is not a judge. Okay, and judges can make judicial decisions, but, the Labor Relations Board can only make an award. Okay. Because they're not judges, they're not bound by precedent. But most of our administrative tribunals, like employment standards, labor relations code, try to follow precedent for certainty and predictability. The Workers' Compensation Board, though, and I've had experience here, can flip-flop back and forth. At one point, I had a client whose wife died, and he was going to get death benefits from the Workers' Compensation Board. And they used to give it in a little bit each year for a period of time, because if they gave it to somebody all at once, it would put them in a very high tax bracket, and the government would grab most of it back. But when he went to get his death benefits, they said, "Here you go, one lump sum payment." And he said, "I don't want one lump sum payment," because he was already in a really high tax bracket. And they said, "No, that's the way we're doing it." So we went to the Workers' Compensation Board, and they said, "Well, we've changed our mind. Yeah, we used to do it that way before, but now we're going to do it this way." And we appealed internally, and they said, "Hey, we're not bound by precedent, so we've decided to change." That was it. Okay. And so my client said, "Well, what do we do now?" And I said, "Well, you can appeal to court." And he said, "No, never mind." 11 months later, Workers' Compensation Board decides, no, the other way was better. And so they start giving periodic payments. my client comes back to me and he goes, like, what do we do? And I said, well, we don't do anything because when you decided not to appeal to the court, you had 60 days to make up your mind. The appeal period's gone by, tough luck. So they can flip-flop back and forth, but most don't. Labor Relations Board has built up a body of precedent that they follow very carefully. They're not required to, but they do. Okay, municipal bylaws and regulations. Dog licenses, business licenses, who shovels, who's responsible for shoveling the street, snow off the street in front of your house, those sorts of things. The municipalities do their own regulations, and there's no consistency, but it is a source of law, and so I mention it in passing. Now, one thing here, municipal bylaws and regulations relates to cities, towns, boroughs, and shires, and things like that. Municipal is used another way internationally, okay? The municipal law would be the law of Canada, or the law of the United Kingdom, or the law of the United States, or the law of France. Municipal domestic law. They're not talking about municipal bylaws and regulations, okay? I also mentioned military law, only in passing. We have the Military Code of Conduct, we've got military judges, military lawyers, military police, military jails, military prisons. So there's a whole system of law for the military, although we're not concerned with it in this course. And then I separated out international law. And this isn't actually a separate source of law. Well, yeah, it's... How do I explain this? The treaty is a contract, okay, and it gets interpreted through tribunals. United Nations conventions are statute laws. We have some judge-made law about disputes cross-border. So it could either be statutes or it could be judge-made law. I separated it out because it's different, in the sense that a contractual dispute in the province of British Columbia is municipal BC law. A dispute across borders takes on a whole different flavor because there's laws of BC and there's laws of Missouri or laws of California that come into play. And so I separated it out. And also, even though we have a international Sale of Goods Act in the province of British Columbia, it is actually the enabling legislation to adopt the Convention on the International Sale of Goods. So it's international because it deals with cross-border, but it is also a statute. Okay, so that's because it's so independently different, I've separated it out. So those 8 sources of law. Now at this point, I should probably start talking about the midterm exam. You'll be able to see one because I'll post it online. But Part A is 15 terms, 18 definitions, and you just match the terms and definitions. The thing here is I want you to understand concepts as opposed to memorization. So the example that I generally use in BADM 107 is if I put down false imprisonment, the actual definition is intentionally and without loss of lawful justification subjecting another person to the total restraint of their movement by either actively causing their confinement or from preventing them from leaving the place in which he is. Do I want you to memorize that? No. What I want you to do is be able to think in terms of breaking it down, intentional, unlawful confinement, okay? And then my definition on the exam will be such that you could read it, and if you had enough time, you could actually work it out. Oh, that must be false imprisonment, all right? Now, the problem with the exam is you will not have sufficient time. So that's why I suggest you do the index cards, practice so you can recognize them quickly. you get 13 of them done, and there's 2 that you have to go back to the materials and look up, then you'll have time to do that. So that's Part A. Part B, let's deal with Part C. Part C is a problem, and you're just going to have to work through it. But Part B, I have 5-mark questions. Okay, well, this would be a good 5-mark question. The sources of law in Canada. List 5 of the sources of law in Canada and briefly describe them. All right. Okay. As I go through the lecture guide, I will try to remember to say, oh, this would make a good Part B exam question, because then by the time you get to the exam, you'll have about 12 or 15 of those, and you could actually pretty much write out answers, ahead of time so that you've got them. Okay. So the next 2 terms that I'd want you to know is substantive law and procedural law. Substantive law are the rights and duties of each person in society. In other words, the laws that we must follow. Okay. So you and I have a contract, and you breach the contract. I want to sue you. How do I sue you? You're sued. No, I can't do that. I have to go to the court registry. I have to fill out their form. I have to pay them a fee. They stamp it. I then take it and I serve it on you personally. Then you have 14 days to file a defense. You may have a counterclaim against me. If you make a counterclaim against me, then I've got 14 days to file a defense to the counterclaim. And then we go to examinations for discovery, and then there'll be a court application for the exchange of documents, and then we get into the trial. There'll be a settlement conference just before a trial. All those rules are the procedural law by which we enforce our substantive rights. Okay. All right. We then get to public law and private law. Public law is the government on one side, okay, and the government on the other. So a constitutional battle of some type, or the government on one side and an individual or organization on the other. So in other words, Regina versus Dudley and Stevens. Regina is the Queen, so the Queen versus Dudley and Stevens. Obviously, this is public law. Okay. What is international law? Well, it's I'm just going to make a change to my screen here because I just realized that there's a problem there. Okay. What is international law? It's defined as a body of rules and norms that regulate activities across legal boundaries of nations. Okay. And the problem with it, as I've already described, is there's no conformity of prohibitions and few punishments. The easiest way to look at this is in Texas, if you murder somebody, you will be hanged. Okay, in any province and Quebec in Canada, if you murder someone, you go to jail for life or 25 years without parole, something like that. Okay, so there's differences across border. There's no conformity, except in some areas. International law is designed to regulate 3 activities, and you can see that these activities are the same as in domestic municipal law of Canada. The first is it regulates activities between states, just like in public law it's between governments, provincial governments and the federal government. So it regulates activities between states, and then just as private law or public law in Canada regulates matters between a state and an individual, international law regulates matters between a state and a foreign person. Okay? And then the third aspect, and the one that we'll be most involved in for the second half of the course anyway, and in our projects, is it regulates activities between the state and, between one person in one nation and one person in another nation. Okay, Public international law deals primarily with the rights and duties of the states and international government organizations as between themselves. And then private international law deals primarily with the rights and duties of individuals from different countries. Pretty straightforward. Okay, the slide number 9, what I've done is I've listed some things that fall under public law and some things that fall under private law to show that there's a few, sort of surprises here. And the list isn't, first of all, it isn't exhaustive, and secondly, it's not a complete division because that would just be too academic in nature. But on the left-hand side is the sources of international law. We get into that in topic number 2, international personality. Are you a national of Canada? Are you a foreign national? That sort of thing. State territory, that's the boundaries of nation. State secession. Africa has blown apart into so many smaller states. There were so many colonies of European countries, and those colonies tended to be big, and they wanted to grab as much territory. They really didn't care about people or language differences and things like that. But when the colonial rulers were expelled, these areas broke up into their countries, and these breakups are still occurring. We see it with Scotland having a vote to try to leave the United Kingdom. We see the United Kingdom exiting from the European community. Quebec every once in a while has a referendum to try to get out of Canada. Some of the states in the United States have organizations and associations that are trying to get those states to break away and become independent countries. So that's what it means by about state secession. State responsibility to aliens. You travel into another country. What's their responsibility towards you and you towards them? That sort of thing. Law of the sea. The law of the sea is now regulated quite a bit with the Convention on the International Carriage of Goods at Sea Act, but there's also regulations about what happens when a ship goes down and the people are in a life raft and things like that. International dispute settlement. This would be the WTO. The World Bank, things like that, okay? The law of war, yes, there is a law of war, and the law of war is generally the biggest and strongest wins and gets to write history. But apparently there's a whole law set out how you treat prisoners and things like that. Okay, that's the public international side. On the private international side, you've got torts. What's a tort? You're not listening, a whack and a hit you on the side of the head. Ow, you can sue me for battery. Okay, that's a tort. Negligence, battery, product liability, false imprisonment, defamation, all those things. Inheritances. Definitely private international law. I handled an estate for a person in British Columbia. We got probate. Turned out there was some property in the United Kingdom. Well, we can't just say, okay, give us that property. What I had to do was get a certified copy of probate, take it over there, lodge it in their judicial system, and begin proceedings there to have the property transferred into into the representative's name. So inheritances falls under non-commercial private international law. Nationality. I'm not quite sure the difference between international personality and nationality. I guess it's international personality is like my niece who has dual citizenship in the United States and Canada. Nationality is your relationship for contractual purposes and things like that inside Canada. Marriage and divorce, definitely private international law, although we are sort of breaking some of those barriers down. For example, if you have a situation where a husband and wife break up in Canada, and the husband takes a whole bunch of money, owes alimony payments to his former spouse, and he heads down to Nashville, Tennessee. We now have a system where there's no prohibitions and punishments in the past, but we've now decided to institute a prohibition and punishment. You cannot do that. You have to pay alimony, right? So what happens? Well, in Nashville, eventually your BC driver's license becomes invalid. You have to get a Tennessee driver's license, and you go to get it, and gosh, you don't get it until you pay your alimony. Okay, then there are commercial, private international law. The first thing is obviously contracts. Second thing is transportation. The third thing is money and banking. The fourth thing is financing. The difference between money and banking is money laundering and banking institutions. Financing is things like how you raise capital by giving mortgages, chattel mortgages, which are now called personal property security agreements in BC, hypothecation of shares, things like that. Securities, the Securities Exchange Commission are, provincial and federal. And then intellectual property, which seems a bit strange because generally you file trademark registrations with the federal government here and the government of Australia and the government of the United States. But if somebody infringes your trademark, the governments don't do anything, okay? You have to do it yourself, and so it's called private international law. Okay, that completes topic 1, so you can see that they are not quite as extensive as a chapter in a textbook, and yet it covers quite a bit of material. Okay, topic number 2 is sources of international law. And we start with the sources of international law as established by the United Nations. And how did they do it? The United Nations formed the International Court of Justice. And there's a statute of the United Nations which established that court. And in there, in Article 38, they listed the sources of law that the court could look at. And that has generally become the rule that it's applied when an international court or even a domestic court looking at an international transaction. It's a list of laws that they can take into consideration. Okay, so the very first one is treaties. Number 2 is conventions. Then international customs, which is if a custom is consistently and regularly observed and recognized by nations, then they must. Then there's an obligation to follow them. Then there's general principles of law recognized by civilized nations. And my bone of contention in here is I'm not certain that we're all that civilized. Okay, you look at a lot of countries where thugs are in charge, like Russia, and totalitarian governments and everything that murder and imprison and everything. And all the wars that we've had since time began. I should probably drop the civilized from that. Just say recognized by nations. Okay. So and then the fifth one is judicial decisions, judge-made law, and one twist here. Add to that, in the teachings of the most highly qualified publicists of various nations. We'll get into a little bit deeper consideration in a minute. So I have a bullet at the bottom of the page. It's comity, the practice and courtesy between nations of treating each other with goodwill and civility is one of the guiding influences in the development and application of these laws. So in other words, well, we may enforce your court judgments in our country if you enforce ours and yours, that sort of thing. Okay, next screen we go into, and we're now into slide 12. And we're going to start looking at each one of these sources of law individually. And the first one I mentioned was treaties. Treaty is nothing but a binding agreement between two or more states. So in other words, it's just a contract between governments. Okay, we had the Free Trade Act with the United States and Canada initially, and then that was a bilateral treaty. Okay, two countries. Another example of a bilateral treaty is the treaty that we have with Chile. Canada has a treaty with Chile. We have a treaty with Israel. And a treaty with Colombia. Okay, I don't know what we send them, but you know what they send us: coffee. Okay, that's a bilateral treaty. A multilateral treaty, we have the free trade agreement between Canada and the United States, and they add Mexico. Okay, suddenly it's a multilateral treaty because it involves three countries. NAFTA, the North American Free Trade Agreement, has now been usurped, and we have the United States-Mexican-Canada Agreement. Okay, so they don't call it a treaty anymore, they just call it an agreement. There are self-executing treaties and non-self-executing treaties. Self-executing treaties are effective between a ratifying country without domestic enabling legislation. So in other words, something like the when we all adopted the I'm trying to think of a good example, and I can't. The treaty between Canada and the United States regarding the Columbia River. Okay, and we'll get into that a little later on. The Columbia River Treaty did not need legislation in Canada and the United States. It was an agreement between the governments. A non-self-executive treaty requires enabling legislation. So the North American Free Trade Agreement, when it was brought in, had to have Canada, the federal government, pass a law adopting it. And the United States had to pass a law adopting it. Mexico had to pass a law adopting it. When they replaced it with the USMCA, again, Congress had to pass it, Canada, the federal government, had to pass it, and the Mexican government had to pass it. So those are non-self-executing treaties. Okay. Plenipotentaries are the individuals that negotiate these treaties. They are heads of the government, either the Foreign Secretary in Canada or the United Kingdom and the Secretary of State in the United States, and they have full power to negotiate a treaty. Full power to negotiate a treaty doesn't necessarily mean to sign it. Okay, so they're the ones that go in and negotiate the treaties, and then it's either self-executing or non-self-executing. One legal maxim that I want to get into right now is really important, and that's pacta sunt servanda, which is an international legal maxim that says treaties or agreements must be served. Okay, so they are binding. How are treaties terminated? They can either give formal notice, okay, or you can have a superseding treaty, or it can be terminated once the purpose is fulfilled. Giving notice, the NAFTA had a provision in there that said either party could give notice that in 10 years the treaty would come to an end. The reason for the 10-year period was there were so many side agreements with respect to water and oil and things like that, whereas if you could just cancel the treaty, there would be chaos. You know, an oil pipeline that's built between the countries pursuant to the USMCA If it was half done and Canada said, "Oh, we want to get out of this," well, chaos. And so they have this 10-year provision. Well, that was when Trump was running around. I'm going to just cancel the thing. I'm going to just cancel the thing. Well, technically, if they just stopped doing it, it would be canceled. But the legally, and Congress and this, well, I don't know about the Senate because they're a bunch of toadies, Trump toadies, but Congress said, well, we can't. Okay, Trump cannot cancel it. We renegotiated it just because they're bigger than we are. Anyway, so you can give formal notice and get out of it, or there could be a superseding treaty. Well, we've had the free trade agreement between Canada and the United States, which was superseded by the North American Free Trade Agreement, which was superseded by the USMCA. Okay, and then the third one is a treaty that is terminated once its purpose has been fulfilled. And 2 terms ago, I said, gee, I couldn't think of one. I thought the Columbia River Treaty was actually completed, and so the treaty was null and void. But apparently it just came up for renewal because there's some ongoing aspects to it. Okay, so that takes care of the first topic, treaties, and I'm just going to stop here for a quick break. Okay, I'm back after the short break. On slide 14, I have shown you the beginning of the enabling legislation. Okay, so enabling legislation, I'm writing that on the whiteboard that you can see behind me. When I do that, that's a term that isn't in my lecture guide that you may have to know for examination purposes. Okay, so it's the Canada-US Mexico Agreement Implementation Act. So Trump has decided to call it the USMCA. As far as Canada is concerned, it's the Canada-United States-Mexico Agreement. Politics. Anyway, that finishes off treaties, and now we get into conventions. Convention is a binding agreement between states. The only difference between that and a treaty is it's not negotiated individually between countries. It's done by the international organization known as the United Nations. It creates only political and moral commitments until a country passes municipal enabling legislation. Notice the word municipal. That doesn't mean the city of Vancouver, the city of North Vancouver, the city of Richmond passes it. What that means is Canada passes it, or if it's something that relates to the provincial powers under the Constitution, then the federal government doesn't pass it, the provinces do. And 2 examples are the United Nations Convention on the International Sale of Goods Act, and you notice it says RSBC 1996, Chapter 236. That's because that means Revised Statutes of British Columbia. Civil and property rights means contracts and ownership of property, and that falls under Section 92 of our Constitution, and so it becomes provincial power, and so the provinces had to pass the enabling legislation. I wanted to get a copy of that for the course, and I thought, well, it's a convention, so it had enabling legislation had to be the federal government. So I went down to the courthouse library and began going through the federal statutes and couldn't find it. And finally, I threw up my hands and I called the librarian, and she said, oh, well, it wouldn't be in the federal statutes. It's a provincial matter. And so I went to the revised statutes of BC and found the enabling legislation that adopted that convention. And on the next slide, you can see that. There's the Convention on the Unification of Certain Rules Relating to International Carriage by Air. So this governs how much a person's estate will be paid for the death during an air crash, how much you get compensated per kilogram for your cargo in the plane, how much per kilogram do you get compensated for your carry-on luggage. The other one that we're going to look at in the course is the Convention on the International Enforcement of Arbitral Awards, but we'll get into that a little later on. Okay, so Slide 16 is the enabling legislation, an example of that for a convention. And then the next slide is the third source of international law, and that's customs. Rules which have been around for such a long period of time or so generally accepted that they are described as customary laws. A really good example of that is Genghis Khan, who lived from 1162 to 1227. He created the whole concept of immunity for ambassadors. And that's a customary law still recognized today. So he conquered, a huge area, and he was a barbarian, and when he conquered, he really conquered. But after he took over an area, it was so important for him to be able to do commerce with other nations that he actually sent out emissaries saying, if any of your representatives, your ambassadors, they didn't call them ambassadors in those days, but any of your government representatives that come to our country, I will protect them. They can safely come and safely leave. This became such a standard practice that we now have that today. And it's customary law that we give ambassadors immunity. Genghis Khan was quite a character. He actually was one of the first people who started looking at women and giving them equal rights. They were treated much better inside his empire than they were elsewhere in the world. Okay, so that's customary law. Rules with respect to customary law. It's the doctrine of incorporation. If you incorporate it into your country, then it becomes a customary law. As long as it is adopted by legislation, or by court decision, or by local usage. And Incoterms are a perfect example of that. The International Chamber of Commerce is not a lawmaking body, but because they try to enhance and facilitate trade, they said one of the biggest problems was sending goods from one country to another country, FOB, CIF, delivery duty paid. All those terms were quite confusing because there was one called FOB point of shipment and FOB point of destination, and people would get them confused. Oh yeah, it's FOB, which means the buyer's paying. No, the seller's paying, and they'd wind up in court. So the International Chamber of Commerce established these rules, and they have become customary law because businesses use them so that everybody knows what is meant by FOB. It's now FOB, and it only means point of shipment because FOB destination has been changed and it's a different term entirely that's used for that. Okay, and the only way that an international custom cannot be part of municipal law of a country is if they persistently object to it. No, we will not protect your ambassadors. No, your ambassadors do not have immunity. As long as a country keeps saying that, then that customary law will not become part of their country. Okay, general principles of law recognized by civilized nations. Oh, there's that word civilized again. I really must get that out of there. Anyway, a perfect example of this is Lex Mercatoria. Business people in the early feudal Europe couldn't wait for governments to finally decide on a court system, on a system of laws, and the wheels of government move so slowly. Business people wanted to make a buck, okay? And so what they did is they began to establish rules, contractual rules, rules of respect to transportation, rules that governed commerce between themselves. Well, they had to have rules and they had to have a way to enforce it, so they established their own courts. They were called the Courts of Dusty Feet, okay? And although it's the French term, and nobody quite remembers exactly what it meant or who did it or why it was used. One of the theories was they were called the Courts of Dusty Feet because business people were always traveling and they always had dust on themselves and they would come into court. So they had judges, they had a whole system of laws worked out. And these principles became recognized by the countries as really necessitating applicability for business purposes. And so eventually the Lex Mercatoria, which is a body of commercial law used by merchants throughout Europe during the medieval period, and it evolved similar to the common law. In other words, judges made decisions, and that's how they became enforced. And they had their own mercantile courts on their main trade routes. And it functions as international law of commerce. Perfect example. Lex Mercatoria has now been incorporated into and becomes part of our legal system. The next slide deals with the teachings of, the judicial decisions and teachings of the publicists of various nations. Obviously, judge-made law can be used as a source of international law, whether it's applied as precedent or whether it's just considered to be a guiding principle. It doesn't matter. Judicial decisions as a source of international law. Then there's this thing, and the teachings of let me just use the proper phrase here to make sure I get it correctly. Teachings of the most highly qualified publicists of various nations. In Canada, until very recently, in court, you could not use a textbook. It was only statutes and regulations and judge-made law. Okay, in other words, primary sources. Internationally, cross-border, there was no judge-made law. There were no statutes that were applicable. There were no regulations that were applicable. There was some customary law, but it didn't necessarily mean it was recognized by everybody. And so the United Nations said, okay, we can look at the wording of treaties, the conventions, customs, and general principles, but we can also look at judge-made law if it's cross-border, and we can also look at legal writings of judicial scholars. In Canada, there was one called, written by a fellow by the name of De Castle, and unfortunately I've got a sample of it in my office at CAP, which is unavailable for circulation, so you don't know what it looks like. But these authors looked at this sort of custom and legal principles that some courts were applying, and they wrote books, textbooks, and talking about what the rules seem to be for cross-border matters. And courts would say, oh, okay, I can look at that because it's not just a textbook written by anybody. This person is really well known. Domestically, we are seeing more and more the courts rely on textbooks of well-known authors in certain areas where there's no judge-made law. And I even had one sort of minor involvement in one of those. The Smythe, Silverman, and Eason textbook, The Law and Business Administration in Canada, became the best and well-known business law textbook. I had a client who had a dispute with the municipal government, okay, not a municipal law, but the municipal government in his municipality, and he wanted to sue them, and they had a rule that said, well, you cannot sue us for Rylands versus Fletchell type damage, which means if the government had a ditch out in front of your house and the water overflowed and damaged your basement, you can't sue the government for that. It's just, your tough luck because it's so important to have ditches that you can't have the governments going bankrupt. And and that's exactly what happened. This bank overflowed and his basement was flooded and considerable damage was done. And he wanted to sue them. And I said, well, they're saying Rylands versus Fletcher, you cannot sue us. But really this was negligence which is different, right? Because you had told them that there was garbage and stuff in the ditch, and it was municipal property, and if the culvert got jammed with all this muck, the water would flood, and that's what happened. So because you told them, it's really negligence on their part. And it was a small claims matter, and so the client was going to do it himself. And he said, I really don't know how to explain that to the court. And I said, well, take in Smythe Silver and Easton and open it up and say you're relying on that. And in court, he did that, and the lawyer for the government objected on the basis that only case law and statutes could be used in court. You could not look at textbooks. And the judge said, oh, Mr. So-and-so, no, I don't think there's a problem here. The Smythe Silver and Easton textbook is so well known that I think we can rely on it. And the guy from the government went, and it was, and the municipality was held to be negligent, and the fellow was compensated. And the lawyer said he wanted to appeal this. First of all, it was very costly to appeal it compared to the damages that were going to be paid out by the municipality. First, and then secondly, there was no way that the municipality wanted a written judgment by a higher court saying that a textbook could be allowed in a situation like this, because it would expose the municipality to all sorts of liability for negligence. So the client got compensated, and the appeal never took place. But since then, and not because of that case by any stretch of the imagination, but since then, courts have been willing to look at the best known textbooks of the best known authors when there's no case law or statutes applicable. Okay, so we're going to get into an example of this. First of all, you can actually say that De Castle is an example of the teachings of the most highly qualified publicists. But we're also going to look very carefully at a case called Sharn Importing versus Babchuk. For other reasons, we're going to look at it. But the nice thing about that case is, number one, is it is a sample of a judicial decision involving an international transaction. But it's easy to read and easy to understand because it's international in Canada, so it's cross-border. It involved BC, Alberta, and Quebec. And number two, the judge in there actually did reference a textbook of a highly qualified publicist. We'll get into that later, but for the time being, that's just the example of the source of law here. Okay. That brings us to the end of topic 2. The next topic will be number 3, and I'll do that by way of another video later on. So that's it.